Hello, everyone, and welcome to Negotiating Ideas, a podcast about political thought on democracy, rights, and pluralism. In this episode, I talked to Dr. Haroun Rahimi, an assistant professor of law at the American University of Afghanistan. In his research, Dr. Rahimi studies law and development, institutional reform, and Islam and politics. His recent paper, A Constitutional Reckoning with the Taliban's Brand of Islamist Politics, A Hard Path Ahead, was published by Afghanistan Institute for Strategic Studies before occupation of Afghanistan by the Taliban. His recent study, Afghanistan's Law and Legal Institutions Under the Taliban, is available on Melbourne Asia Review. Apart from these two papers, I have discussed with him the notion of rights and how the contestation between the liberal and Islamic fundamentalist notion of rights took place in Afghanistan, how the law scholars studied the conservative but totalitarian movement of the Taliban, and finally why the legal scholarship on Afghanistan has been avoiding a critical approach vis-a-vis the Taliban in the last 1 and 2 years. Dr. Rahimi, welcome to the Negotiating Ideas podcast. Let me start by asking you the question, what are the key contributions of law and legal studies disciplines toward producing knowledge about the Taliban and Afghanistan in the last 2 years?
So, as you know, after 2001, Afghanistan was starting to rebuild a new country, a brand new country, under ruins of civil war um, and a very long period of Taliban rule, half a decade, 5, 6 years. So there really was very low starting point, and there was public institutions have had almost all of them collapsed. The state was really non-existent. If you read the descriptions of the early politicians like Karzai about what he came to after the Bonn conference in Kabul and presidential palace, it just gives you a very stark picture of like the lowest starting point for the country. And one of the key, kind of one of the top priorities on the agenda after 2001 was rebuilding the country's legal system. The idea was that Afghanistan need a constitution that guarantees a bill of rights for the individuals. It needs a effective judiciary that can resolve disputes over property rights, disputes in family areas, and also Afghanistan need a criminal justice system that honors and respects due process. Many of those issues for in the context of Afghanistan were kind of new ideas. As you know, during the reign of communism, due process was not a thing in the country. During the Mujahideen, due process was not a thing. During the Taliban, due process was not a thing, meaning that there was not a lot of interest in procedural issue of how you can have fair trial in the country. Human rights, just the idea that the human beings enjoy basic rights and that the state has to respect and enforce those rights, were also very new for the country. We For a very long period, at least for 3 decades, there was an interruption in those kind of conversations in the country. So there was a very large order to do all of this, and there was a lot of attention by the international community. There were a lot of emphasis on training Afghan lawyers in these new ideas, and many public and private universities emerged that would graduate these new individuals. International community provided many a scholarship for Afghans to go abroad, study in graduate schools, law in areas of law, and come back and bring what they've learned and implement in the country. As a result of that, in a span of 20 years, Afghanistan really transformed. We had a legal system that, at least formally, we can talk about the issues of implementation and enforcement, guaranteed basic rights for the citizens, guaranteed equality before law. There were elements of due process. We had an adversarial system, meaning if we went to a court, if government accused someone of a crime, there was a prosecution that was supposed to make the case for the government, and there was access to the defense attorney that were supposed to defend the accused, and a judiciary that was formally impartial to decide the final case. And many of these young people who graduated over the past 20 years, kind of with these ideas, joined the legal sector that was growing. and they were a big part of this post 2001 order that emerged. Ideas of law were central to this, and it kind of diffused to the public as well. As you remember, many people, as you know, many people in Peru today use the language of rights. It is something new in Afghanistan, so it means that those ideas penetrated society on a very deep level. Even in rural areas, people think of rights, and they use the language of rights. They deploy that language to make demands now against the Taliban, but in the past against the Islamic Republic. When Taliban came to power, all of that changed. Taliban, as you know, pride themselves on their version of legal system, which they believe is divinely ordered, and they have basically set to transform the country's legal system according to their vision. We can talk more about what that is, but fundamentally, they broke down the system that was built, and they are trying to create their own version that reflects their own values and their own ideas in its place.
Well, you mentioned about how these concepts of rights were recent in history of the country. I just remembered reading the genealogy of the Universal Declaration of Human Rights. While the committee was trying to draft the Universal Declaration, the chair of the committee, who was President Roosevelt's wife, Eleanor Roosevelt, she wrote a letter to Mahatma Gandhi asking, of course, she was engaging with different politicians and intellectuals, but a part of it, Gandhi, and asking him how they can contribute from Indian standpoint. And Gandhi's response was, well, I have grown up in a culture, in a civilization where duty and obligation has been emphasized rather than rights. And I suppose that has been somehow the same in our civilization. In Iranian civilization, when you read Karim Soroush, an Iranian modernist Muslim Islam thinker, he also says, differentiates between rights and obligation, and how in Islamic civilization there's much more emphasis on obligation. But however, in the last 100-year history of modern Afghanistan, the issue of rights were discussed, deliberated, at least by the constitutionalist movement, and not just in the last 20 years. It emerged in the 1920s with the very first constitution. So do you see the discussion over rights, or how we conceptualize the notion of rights, different from 2000, early 21st century to early 20th century? How was this conceptual differences then?
You are absolutely right that there are precedents. So it is, if you look at history of Afghanistan, this is the post 2001 would not be the first time these ideas emerged. But you have to also at the same time realize that what the concept of right means in a liberal tradition, as absolutely you know better than I do, is very much different than what they had in mind in the 60s, or they had in mind in the 20th century, in the early 20th century. For example, Amanullah Khan wanted to create a government of laws in the country. And his idea was that the state should have the authority to define the rules and enforce them. He was not very his idea was not that an individual bears rights and those rights are limits on the power of a state. He did not have that idea. He himself saw himself as a king that would rule by law, and he understood law as limits of the king. But the idea was not that their individuals have rights that are in a way inviolable by the state, and they define the limits of the power of the state. And when you go on even to the constitutionalist movement, and even the 1964 constitution that is that kind of starts a decade in Afghanistan that, as you know, is called Decade of Democracy, and you've studied that greatly. There are ideas of limited government there, because limited government and rights are very much closely linked. Because for individual rights to exist, the power of state has to be limited. Like, that's the whole idea, that individual rights define the limits of the power of a state. So the idea of limited state and the limits on the power of state existed, and the very nascent format, the idea of separation of power existed. But at the same time, king remained the ultimate power. It had the power to dissolve parliament, and there were a list of rights enshrined in the constitution, as you know, in 1964, and those rights were including 2004 constitution as well. But you have to also realize that if you go at towards the end of the chapter of rights in the 1964 constitution and 2004 constitution, there are serious limits. Basically, it says that none of these rights can be used in a way that would threaten undefined terms like national security, sovereignty, and so there are at the time there were very serious limitations on individual rights and how they can be enjoyed. But over time, I think, especially in reaction to many totalitarian regime that came into Afghanistan, both crimes of communists and then I think what happened during the Taliban and the Mujahideen, I think people had an understanding, innate understanding that they really, as individuals, have to have a place in politics. Maybe they don't have the language to articulate it, but I think demand for liberalism and individual rights kind of grew in reaction to all the horrors that happened in the country. And in 2001, I think the population was receptive to this idea that the politics should be based on individual rights. But the sad thing is that, as you know, the post 2001 order, even though it formally committed to individual rights, but in practice it remained a very much still an authoritarian kind of a system on many levels, especially on levels that mattered, like day-to-day people's interaction with the police, for example. It did not differ from like a brutal police regime that may exist in another country. I mean, there were certain groups that were able to form effective civil society that could protect some of their rights, high profile, but ordinary people did not experience a state where the rights really mattered.
Yeah, so we didn't have actually, like many other, even in the liberal world, Afghanistan didn't have a Bill of Rights. Even, for example, name a country like Australia doesn't have a Bill of Rights, but there is a system of order of legal provisions which entitle people to certain things, and that's called rights. So let me now come back to my first question. If you can map for us the common trends of legal scholarship in last 10 years or 20 years. But I'm particularly interested with legal scholarship, which is dealing with the concept of state and rights here, as you were discussing. What are the common trends?
Right. In terms of constitutional studies in Afghanistan, as I said, we start at a very low point. The first constitution of the post-2001 constitution, I think, is a very valuable document. And I think many people, because of problems of implementation and the problems that many Afghanistan presidents abused the power given to them under the constitution, and many political opposition saw the constitutional ambiguities as enabling those abuses. The constitution, I think, lost respect in the eyes of many people. But if you go back to the time when it was being drafted, it was a very important document, and it was a result of broad participation from different sectors of society. I remember I was in Herat University. I was in Herat, not Herat University, and people would come and we would go to these gatherings at different places, and the different texts of the constitution were discussed. Sorry, there was not a text yet, but it was the idea, okay, these are principles that the constitution is going to focus on. What are your ideas? And literally people, the representatives from the central government went to village and hold these discussions and collected opinions. And there was a sense of collective participation in creation of this document. I mean, I know Taliban would like to present it as like foreign imposed, but the people who've done detailed research on the history of the constitution, for example, a friend of mine, Dr. Shamshad Pasarleh, has interviewed the drafters and then the people who were involved in the document, do not relay a story of foreign imposition. The international community basically left it to Afghans to find a document. Obviously, they stressed to them that the international community would like to see protection for more women's rights and would like to see minority rights being protected. The same demands they're making on Taliban right now in broad terms. But in terms of what the document should look like, it was left to Afghans to decide. And I think it was a very valuable document from many points of view. From your book, you talk about negotiating diversity. If you look at the internal discussions when the document was passed, real negotiation and compromise happened. For example, issues that are culturally sensitive in the country. The title of the national hero was negotiated in exchange, for example, for King Zayashah receiving the title of the father of the nation. The issue of language, for example, the language of the national anthem was negotiated. Okay, well, it's going to be in one language, but it's going to name all the ethnic groups in the country. The issue of, okay, what's going to happen to the traditions that are against Islam was negotiated. The provisions added in the constitution that required the state to take actions to remove those. So it was a real give and take, a real conversation that produced that document. It's an imperfect document, but I'm saying we should really understand that its historical context was a valuable document.
Well, so that is the public discourse on particular process of crafting constitution. So what about academia? The Kabul University, which is the oldest one, you have two, at least law has been studied in Afghanistan either through Sharia school, which is theology, and the modern faculty of political science and law. To what extent professors, intellectuals contributed towards knowledge production when it comes to legal studies?
That's a very good question. There are people who have studied the Constitution in the historical context and also the making of this Constitution. Many in higher education, in academia that I know of, have produced valuable work in both Farsi and English. Some of them are descriptive. As you know, law in Afghanistan is often taught in doctrinal terms. So empirical research and a study of law in terms of its function in society is not very common. Law is understood in terms of explaining and defining the existing rule. It's very doctrinal. It's very formalistic. So there are many people who have tried to explain and analyze the provisions of the Constitution in order to make it more understandable, to share their ideas about what it means to other lawyers, and also with the eye that some of their books are going to be used for students. There was an increasing demand, as you know. Law schools and Sharia schools grew, and there was an increased demand for material in national languages for people to study. So like textbook style. But there were some law and society studies as well. Many of them was conducted by people who studied abroad and were more introduced to the idea of law and society and law development. People who used empirical kind of tools to study how it functioned in its context. In terms of rights, there are I think that area of human rights was very much, as you know, had international interest in it, and there was a lot of support. I honestly would be hard pressed to think of any critical study of that. I think many of the studies in the space were reflective of the mood, which was promotion of all these rights. But and as you know, in many of my writings, I criticize that lack of critical lens. When it comes to the issues of liberal values, like how individual rights can be reconciled with Afghanistan's communal rights, which most Afghans understand themselves as part of the small communities, and also people's demand for Islam to have a larger role in society, a public role for religion. I think some of those issues were uneasy in terms of the relationship to the liberal discourse of rights that were being sponsored and promoted. And I think that caused, since many of these projects received some sort of funding and support from outside, I think that was an obstacle in my mind in terms of mainstream studies. And as a result of that, I think the discourse of right became a lot more fragile because it was much more vulnerable to critical attack once all those international support kind of went away. For example, as you know, Afghanistan was a place where there were a lot of war crimes committed, but you would be hard-pressed to find a study by a respected Afghan scholar on the war crimes committed in the country. I think there was no appetite for it, and there was a lot of risk to doing that kind of work. In terms of human rights, although Afghanistan, as you know, most Afghans, if you talk to them, would say that they want Islam to have a public role in society. The general kind of approach in the circles that were seen as main benefactors of the post-2001 kind of a scholarly world and civil society was not to spend time on those ideas. There were research done on how these ideas are compatible, but I think they were not critical enough. And my idea is that they define certain limits for what they can study. No one, I think, imposed it, but it was a matter of incentives and people's understanding of what they wanted to see, their own views, not what the country where the country was, and how where the country was could be bridged. I think the idea was that compromising on those issues would be, at the moment that the country was at war with a very brutal regime that tried to discredit the post 2001 project. I think there was ideas that critically taking the criticism of the regime in terms of its fundamental normative underpinnings seriously would have been a betrayal of a project that I think many people were sponsoring. So this role of being an activist or a promoter of certain ideas, and at the same time being a scholar that is critical, trying to understand things as they are, I think sometimes clashed.
Interesting, and this also brings another issue to my mind, that if we have, I mean, in terms of legal scholarship production and discourses, we fail to engage in a critical manner, as you mentioned. What are any other examples in our neighborhood, in Afghanistan neighborhood, wherein such kind of debate, negotiations, and reconciliation between a liberal notion of rights and the one which is deeply embedded into the customs, but at the same time a religion like Islam. What are the models that we can borrow from?
That's a very good question. As you know, we live in a very difficult kind of region, so regional comparisons are interesting, but very difficult to do. Iran, for example, as we may get to it later on, has a theocracy. It's a theocracy, and the power is not accommodating of those kind of conversations. I think the opposite is sponsored there, and meaning that there are, as you know, this SAMT, for example, is an organization within the government that its job is to produce humanities books, and I believe you've tried to get your book published in Iran, and you face censorship there. So there, the idea is that we try to promote the other, meaning that we want to promote that in their case, the Jafari understanding of Islam is the one that needs to receive wider perception, and they feel like they're working against the foreign ideas that the international scholarship is posing on them. So you have kind of the flip side in Iran. But obviously, Iran has a vibrant academic community. Many of them work outside Iran because that's where they have freedom of thought. And I think there you see interesting synthesis happening. For example, you earlier mentioned Dr. Surush, who's an Islamist philosopher. He still believes in liberal rights, I believe. He's right that he talks about that liberalism can go to an excess. And that's why, for example, on issues of LGBTQ, he hasn't really come out and defended them, because he feels like in terms of morality, there should be limits on people being able to satisfy their internal desires, but where that line is. So it kind of questions the sovereignty of human desire in a sense that any form of individual expression should be honored and respected from a moral perspective. But he is very much, I think, moving through liberal tradition in terms of centering the dignity of human being, privileging human and individual, not necessarily seeing individual as a tool within a system, right? As a cog in a system, ideological or not. In Pakistan, it's a different story. They have the colonial history, as you know. They kind of inherited their legal system from the colonial system of Britain. They have a parliamentary system that resembles the British system. But there have been an Islamist movement there. I think it's a good example. There were leaders in Pakistan who tried to Islamize the country, Islamize that colonial system. And you could say that they have reached, in certain areas, an institutional way to deal with this. They have Sharia courts on federal level that is supposed to review the laws to make sure they comply with Sharia. Those things, I think, provide forums where these conversations can happen in a way that a synthesis could be possible. And for example, the Pakistan Sharia Court opinion on ban on interest, riba, which Taliban also share, is, I believe, like multiple 100 pages long. So it is a discourse that is taking place. It's not like Afghanistan, that the top leader is just issuing two-liners right now, saying this is the final word on this matter, and that's it. The Sharia courts in Pakistan deems it necessary to engage and explain its opinion, like the Supreme Court of the United States does. They don't always get it right, obviously, and they may not reflect the general sentiment of the society. And many have criticized them for being close to the army in Pakistan. But I think there are forums, and they have thought of institutional ways to accommodate the Islamist demand that is in the country with the formal legal system that is supposed to accommodate individual rights. Obviously, there are areas where the populism has made things worse because, as you know, for example, with regard to blasphemy, it has become such a sensitive issue that the conversations are not happening in terms of those sentences. That the conversation is happening around violence and with violence, and there's really no conversation. It's the use of violence that is intimidation, and it's just basically scaring anyone to engage critically and thoughtfully about these topics. Even governors who spoke in Pakistan in favor of due process for people who were accused of blasphemy, even non-Muslim, were lynched. So you have those excesses. I'm not trying to paint a very rosy picture of Pakistan, but at the same time, if you look at it on an institutional level, they have found ways, I think, to at least start thinking about how the Islamist demand of the public can be reconciled with a liberal political order that protects individual rights.
Yeah, interesting. So you flagged at least two things. One is Roshan, what we call in Farsi Persian, Roshan Fikri Dini, the model of Soros, but at the same time, institutional reconciliation. In your writings, you also try to differentiate between fiqh and state law. Clearly, you say that these two could not be applicable, and Islamists should at least appreciate that fiqh is not a state law, and the state is not made, is not supposed to be used instrumentally for enforcing a common version of morality, be it, for example, principles and provisions of fiqh. You can discuss this also, but at the same time, I wish to ask you also, how about some other multicultural experience, like in India, where the time that Indians were negotiating, crafting their constitution, unlike Afghanistan, which was crafted like in a couple of months, it was a very lengthy process. It took them years, and one of the debates around that was around concept of Islam and the rule of minorities, particularly Muslims, and the legal structure and institutions of the state. So finally, they came into an agreement wherein Islamic fiqh, with respect to personal law or civil law, was allowed. But when it comes to public law and criminal law, the civil law of the state or the secular law of the state was prioritized. So now, and a Muslim in India has the possibility of it with respect to, for example, purchasing or dispute with respect to marriage. They have the option to opt either state law, the secular one, or the Sharia law. Many other Muslim states also came up with such kind of provisions. What do you think of that?
So you're absolutely right. In India, as you know way better than I do, secularism is supposed to be the enabler of this diversity. People can hold different religious beliefs, but be part of the same polity. And there will be common rules that apply to everyone when it's a matter of relation between individuals and the states. If it's a matter of relation between individuals, then if both individuals share a same faith, they can subject their private matters to a religious law of their choosing. Right? That's a approach that I think should be celebrated in India. As you know, secularism in India is also under attack. There is a Hindu nationalist government that sees India as a Hindu nation and is trying to kind of push back against that neutrality of the state on religious issues that was the cornerstone of the Indian constitution. Afghanistan is obviously a very different country. We have almost like 99% Muslim. So even if you think of in terms of democracy, of what people want, I think you would see a different vision for the state, right? And the problem is a little bit different in the country. Afghanistan is a very diverse place for sure, but I think people don't think of the diversity in terms of most people at least don't think of it in terms of removing religion from public space. I think most Afghans would agree that religion should have a role in the public space. But then the question becomes how you can actually negotiate. What should be the relation between politics? By politics, I mean coercion Because, as you know, a state fundamentally, it's a coercive institution, right? It monopolizes legitimate use of violence, and its fundamental kind of idea is coercion, right? There is a police and army to coercion. How can you kind of reconcile this coercive power of a state with the idea of religious law, right? For lack of a better word. I think this question has not historically been satisfactorily answered in Islamic thought, and I think especially classical Islamic thought, partly because I think it was not an issue at the time. This became an issue when Muslims became exposed through colonialism and such to different modes of relationship. I think in the classical times, it was a given that a state is going to be religious, right? Even in the West, and I mean everywhere, the idea of religion and state being very much closely intertwined, and religious law being the foundation of legitimacy of the state and the foundation of public relations was kind of taken for granted, right? So there
But
was no,
still,
please.
that's right. And but still, even if we argue that absolute majority of the people are Muslim, that doesn't mean that we ignore the diversity which is inherent in society at other multiple levels, including Islam itself. And you also, I think, in one of your writings, have mentioned that what has Taliban taken wrong is that there are multiple narratives of jurisprudence within Islam and multiple schools of fiqh or mazhab. And when a state picks one and endorses one, that leads to sectarianism or parochialism at the end of the day, because you're pushing the others. You have a Ismaili minority in Afghanistan, a Jafari minority, and even within the Hanafis, there are multiple readings of Hanafis, and not just Deobandis, right?
Absolutely. So the thing is, I was making that statement to maybe try to explain why maybe we don't have very good answers to the questions you asked. Within the kind of canonical of classical Islamic jurisprudence, we don't have very good answers to the questions you asked, because I think those were not the questions that occupied the mind of thinkers in classical time. There were modern Islamists who thinking those about those problems. There are intellectuals who think about those problems in modern times. But since we are kind of talking in the context of Afghanistan and Taliban do not recognize the authority of any of those texts, right? So they believe in pre-modern texts, and in pre-modern texts, there is really very much little said on these issues. We can talk about why that is. But what is the fundamental issue, fundamental kind of conundrum, is that fiqh, as you said, Islamic jurisprudence, is a discourse, right? Islam is not like Christianity, where there is a final arbiter. At least on Catholicism, there's a final arbiter of theology, there's a final arbiter of questions of religious law, and that's the Pope, whose opinion is supposed to be the final saying on these matters. In Islam, from the very beginning, there was a lot more diversity, but over time there was an agreement on methodology. Basically, it's called usul al-fiqh. That is, after the Prophet Muhammad, peace be upon him, passed away, Muslims do not have a direct access to divine law anymore. But it doesn't mean they cannot go on in their lives and think about what the divine commands are in relation to their lives. The way they would access those divine commands is that they would engage with the original text, that is the Quran, and soon after a collection of the prophetic kind of tradition, and apply different kind of methodological tools to be able to extract new rulings from those texts, right? Extend those texts to new situation, right? So around this methodology, there was some level of kind of structure imposed on this discourse, which called fiqh. And something became accepted and something became unaccepted. So there are certain madhabs that were rejected or were seen as heretics, as being unreliable. But within what is accepted, there is great diversity, as you said. There are many madhabs, kind of schools of jurisprudence, that Sunni Muslims consider to be equally, to have an equal claim to the truth. We kind of have a pluralistic kind of notion of truth in Islam because it's unavoidable. If you accept that humans are fallible, meaning that they can make mistakes in their interpretation, understanding of the religious text, and you don't believe that there is a special person who's especially privileged to opine on these matters, and anyone who has the required knowledge and follows the methodology can reach a presumptive answer, meaning the answer that could be true. it is unavoidable that you're going to have a range of opinions that can equally claim legitimacy. It doesn't mean that everyone is going to accept them, and there are critical analysis of different madhabs. Each madhab believes that their methodology and their set of opinions are right for a set of number of reasons, but they cannot claim that someone who reaches a different conclusion is doing that something that is against Islam. That is not something they've said, and that's gives birth to this idea that every mujtahid is right, every jurist is right, as long as they remain within the boundaries of what is accepted as a methodology of how you should actually opine on these matters. But at the same time, as you know, a state has to, in certain areas, enforce uniform law in the country. It became more of an issue when the state became much more involved in people's lives. Pre-modern states did very little, right? And therefore, they were not very involved in people's lives. The people were able to engage in dispute resolution based on whoever mufti or whoever jurist they trusted more. They could go to them, submit their opinion to them as their problems to them, and they could opine, use their own reasoning and other reasoning, and determine the facts and apply it to that opinion to the facts of the case and come up with a resolution. We did not really have a systematic way of thinking about the state law yet. But when modern states became a thing, in modern times, then it became much more serious issue, because the state wanted to create civil codes, wanted to create criminal code. And the idea was, okay, which opinion or which madhab, because as you said, within madhab there are diversity of opinions, which one the state gets to choose, right? Most Muslim countries decided that a state is free to choose any opinion from the range of opinions that are accepted, or it can actually incorporate opinions that are not within madhabs. It's for example, could borrow from experience of other countries, as long as those rules that the state makes into law do not violate the issues that are subject to consensus within Islam. Meaning, it does not go against certain basic principles that are not matter of opinion. They are, at least within most kind of circles, are considered as being accepted and agreed upon. As long as the state does not violate those, and as long as the state does promote public goods, and those are called maqasid al-shar'i, basically a purpose. The idea was the Sharia had a purpose, and you could look at the texts and inductively come up at certain goals that you think Sharia is trying to promote. And as long as the state's promoting those, then what the state makes into law is valid, right? As a Muslims, you have to follow it, right? And in many areas that it still was possible, people are still like private areas where the state should not intervene. Like it's matter of, for example, your religious practices, the matter of how you grow your beard. The idea was that a state does not have to come in and arbitrate those questions for the people. Then you leave it to people and to make their choices based on a range of opinion that exists, the madhab they follow, their upbringing, their community they live in, and basically make those private choices for themselves. But in areas that the state would intervene, that was the accepted methodology. And that's what happens in most Muslim countries. It was until the Islamist movement that came about and they wanted to change this. They saw Islam as an ideology. It was happened in the time of ideologies like communism and liberalism and capitalism. All these ideologies existed. And they kind of transformed Islam from that bodies of that discourse, from an ideology. And they wanted to use a state to basically implement that ideology. For example, they had an idea about what the role of woman in society is. Beyond certain norm rules in fiqh, they had an idea about what the role of woman in society is, and they wanted a state apparatus to kind of achieve that ideal. Taliban are unique because they're not Islamists, meaning they don't think in modern terms. They are traditionalist, classical kind of Hanafis, they claim to be. And at the same time, they want to instrumentalize the state to enforce the Hanafi classical orthodoxy in the society. That's a very kind of a unique kind of composition, hybrid. Iran comes close to that because Iran also is not ruled by Islamists. They are very much committed to classical Jafari jurisprudence, but they want us to use a state apparatus to enforce that. To do that, as you said, they have to come up with a state-sponsored kind of version of Islamic jurisprudence. That means that diversity has to be controlled, because they are basically rejecting the idea that the state is making choices. They claim that they are not making choices. It is fiqh as is that is going to be enforced, which is a statement that is oxymoron. It cannot be, a discourse cannot be enforced. It cannot be enforced in terms of uniform laws. Iran is also dealing with that issue. For example, Iran is the country where there is a court for religious scholars, for ulama in Qom, in the religious center, where a person who issues an opinion on matters of Jafari fiqh that is considered to be against the orthodoxy can go to jail. They are tried their opinion, like in the form of inquisition. They're asked about their opinions. Why that is? Because the state is claiming to be enforcing Jafari fiqh. That means Jafari fiqh cannot accommodate diversity, because to accommodate diversity, that would mean to challenge the power of the state. So the diversity has to be policed in that sense. Taliban are doing the same thing. There are many announcements coming, as you know, from the religious ulama gathering, pro-Taliban ulama in Kabul. The supreme leader saying that you should not discuss controversial issues, quote unquote, in public on matters of religion. Basically saying you cannot disagree in public, because your disagreeing makes people think that the state is making choices, that there are
Yeah,
other ways to be Muslim and there are other ways to be Hanafi and there are other ways to be practicing this. It is something that the state would like to avoid, because the state is using violence to enforce one version of it. And if
right,
others say, okay, there are other ways to do it, why are you denying me the right to choose off the accepted opinions, when that, I believe, is more true to Islam I want to practice? That, as you can see, kind of creates problem for the state.
right. Now I'm interested. It's good that you came to this question of Taliban also. You mentioned also earlier that scholarship produced by scholars of law in Afghanistan are mainly descriptive, because they are influenced by the doctrinal nature of law. To what extent such kind of bland, descriptive, explanatory kind of scholarship has somehow turned a blind eye on the nature of Taliban as a very ideological regime which controls diversity, which controls liberty of ideas and thought and consciousness, and simply to the cruelty of the Taliban. Why the legal scholarship and scholars are silent on that?
I don't think they are silent, but what the point I was making was that over the past 20 years, there were a lot of uneasy questions that I think people who wrote in the space of law and society chose to avoid. Because I think it would violate certain normative kind of boundaries that they saw as being operating within. I don't think it was anyone like enforcing it, but I think it was more the paradigm of the time. As you know, that people think in terms of certain restrictions, no matter what. Some of those restrictions are enforced by a structure of power, and I think the way sponsorship of different projects in the country worked reinforced those ideas. But in terms of being critical of the Taliban version, I think it was very difficult to do, because even rhetorically, Taliban had very effective kind of tools to deploy against the state, right? For example, in Afghanistan, it was very hard to have discussions about what are we going to do about hudud and qasas. As many of your audience may know, these are punishments, crimes whose punishments are established within Quran or very reliable hadith of the Prophet. And it was the text of the Afghan laws have always said that they are part of the laws, but they were rarely enforced. Even though most people, seeing the rising crime rates, were very much wanted a more kind of forceful criminal justice system, right? We may believe that would compromise due process and that maybe should not have been, but people wanted it. But there was an unease. For example, in the space I was, students would come and say, why does the Afghanistan state enforce hudud and qasas? You will be hard pressed to come up with an explanation that was satisfactory to the students. I have my reasons. I mean, I think the evidentiary standards for those are very high. Even Taliban do not enforce hudud and qasas as many may think, to the extent that many may think, because they're just simply hard to prove. They choose to, for example, instead of implementing 100 lashes, which is the punishment in the hudud, they choose to implement 39, which is the punishment that is in the discretion of a judge and doesn't have to be the evidentiary standard of the hudud. So even Taliban, I think, have a hard time fully implementing it and remaining faithful even to the classical text. But that was not how the public perceived these issues. The public perceived a state that was failing to be sufficiently aggressive against crimes and sufficiently Islamic, quote unquote, in the eyes of many Afghans, and Taliban capitalized on that. I think there were difficult conversations that could have been had in the country.
How about now, even, for example, we are talking at the first anniversary of the Taliban takeover and occupation of Kabul. So many policy analyses were produced, Afghanistan 1 year and the Taliban, but when it comes to law scholarships, again, to me, they were descriptive. And even if I, for example, respectfully point out to your writings, you discuss, for example, the genealogy of intellectual thinking which influences Taliban's normative beliefs and the system, and you highlight the Sunni Hanafi legal orthodoxy as one of them, the Deobandi branch. But apart from that, reality of Mullah Omar and the way, for example, they also borrowed from the other very recent Islamist movements. Now, I didn't find how do you qualify the Taliban movement as a totalitarian, or leave alone that one maybe as an authoritarian, because this matters. It's question of power, cruelty, violation of rights. If you just describe it for the sake of it, and probably legal scholars prefer just law and order and status quo rather than questioning things.
See, that's a fair criticism. I have written this, as you know, before Taliban were in power, so we were not talking. There was different power in Kabul. In my op-eds, I have pointed out that if one follow, and I think in this paper as well, if you follow the Taliban logic, right, you get to totalitarianism. There's no way around it, because Taliban logic is that the ruler, if you read Mullah Hibatullah's statement to Taliban governors in Kandahar, he basically said there are certain things that are mandatory in Islam, wajib and fard. And he said, my job, meaning the job of the state, is to enforce those, right? It's very important to keep in mind that every human action in Islam, in Islamic thinking, falls within a scale that ranges from mandatory to prohibited, right? So every human action, in terms of how you grow your beard, how you drink water, how you wash yourself, how you pray, all those things are subject to this scale, right? So him saying the state function is to enforce all the prohibitions, all religious prohibitions, and all the enforce all the religious requirements on the population. That means there is really no space for private choice anymore. That means that, and as we discussed, there's really no uniformity of thought on those matters. So it means that he going to choose which thought within the diverse diversity of Islamic thought he's going to choose, and then he's going to enforce that by force against everyone if you follow his logic. That means there is no distinction between crime and a sin, between gunah and jurm, because anything that is immoral, anything that is a violation of your obligation towards Allah, now is a domain of state intervention, and the state can force you to follow your obligation, right? And then he goes on one step further, right? You already see how the image of like no private sphere, no private choice emerges. The state where there is really no distinction between law and morality and religious obligations and legal obligations, right? He goes one step further. He says everything beyond that is permissible, meaning mubah, like it can happen, it can not happen, right? It's ostensibly an area where private choice comes into play, right? Even in relation to your Allah and other people, meaning that even if you remove the state in religious realm, these are the realms of private choices. He says, in that space, I, as a ruler, can restrict what is permissible if I deem it necessary. For example, if you apply his thinking to the areas of girls' education, he's saying that there is no right to modern education for women beyond the basic religious education that you have to receive to be able to practice your faith. There's no right to modern education for women. It's permissible. He doesn't say Islam bans it, right? So he doesn't say it's my obligation to stop girls from going to school. He said it's permissible, but since it's permissible, I can restrict it if I believe that allowing girls to go to school will lead to moral corruption, which is a very subjective kind of choice that one person, based on his views of what women's role in society should be, what women in Afghanistan are, who women in Afghanistan are. As you know, he has a certain judgment of who women are, what their inclinations are, what if they left to their own devices, what they would do, right? He has those judgments, right? And those are not text based on religious text. It's basically his, if you study his psychology and sociology of his movement, you understand where those views come from. Based on those, he's going to make the choice for everyone. So in that space, there's no room for private choice, there's no room for private rights, and the state considers everything to be a realm in which it can use violence to intervene.
Right, right. So this brings me to probably a last question that I would ask you. What are the key issues that law scholars should consider while studying Taliban now as a de facto authority or movement and power, but also Afghanistan that you will suggest?
I think one, because you talked about how the studies have been merely descriptive, and how that may be actually pro status quo, right? Because you're describing things, you're not maybe challenging them or critically discussing them, right? But I think there has been actually a limited understanding, a rich description of what Taliban believe themselves, right? Their legal system to be. They're often bundled together with Deobandis, and many people have reductionist approach to them. They say they are fundamentalist, quote unquote, and they move on. I think it's important to provide rich description of how Taliban actually think about the legal system, what are they doing in details about the legal system, right? I think any critical conversation that is rooted in those kind of rich descriptions is going to be more effective, and it's going to be, I think, closer to the truth. But you're absolutely right that there needs to be. I mean, neutrality is really not an option in the case of a situation like Afghanistan. I think the effective way to challenge the Taliban version is to challenge their claim of monopoly on religious law. And I think to do that, to do and come in and say what you claim to be enforcing is only one possibility, and maybe we can debate as to whether that possibility is good for Afghanistan or is aligned with the goals, what we all believe that the religious should pursue for human beings, different space. But I think to do that, the opposition camp, like the liberalists of Afghanistan, which I consider myself to be a pro-liberalism, will have to deal with the legacy of the past 20 years as well, which was a legacy of violence. If you ask Afghans what they think of democracy, ordinary person, they're going to recall what happened in the past 20 years. If you ask about women's rights, they recall what happened in the past 20 years, right? So there is a need for self-critical examination and basically coming to terms to what happened under the name of liberalism in Afghanistan, to rehabilitate liberalism first, and then I think it can become a much more effective critical tool to apply to a rich description of the Taliban.
Thanks. And lastly, may I also ask you if you can suggest the audience one or two books which you read and liked, probably on the notion of rights or laws of Afghanistan, probably?
I think one of the best book I've read, and it's a classic on the notion of rights. It's MacIntyre, After Virtue. As you know, he's a great moral philosopher. His basic idea, to just give a advertisement for him, is that you really cannot have you cannot reduce everything to individual choices. You have to have a discussion of the conception of good life. Sorry. So the idea of liberalism, that you can reduce everything to choice, and choice can be legitimizing individual choice in itself. He problematizes that. So I encourage a lot of people to read that. In terms of Afghanistan in particular, the legal system, there is a book called Afghanistan Rising. It's written by a professor. Yes, Faiz said, a professor in Brown. He does a very good job of thinking about the Amanullah Khan's legal project for the country in the context of the religious movements that was going on around the world at the time, and these transnational connections to the Ottoman thinkers and to the thinkers from sort of South India. Those are the two books that I can highly recommend. If you are more interested in terms of how Afghans in their daily lives deal with issues of rules, I think there is a good book by Professor Murtazashvili, one of your colleagues and a colleague of ours, on informal order in Afghanistan. It's a very good descriptive work of high quality. If you are interested to know how Afghans actually navigate diversities in their daily lives, there is a great book by Professor Noaf, and it's anthropological work that was done, I think, a northern part of the country. And it basically looks at a community that is dealing with the history of something akin to genocide that was committed against the population, and how different ethnic groups that were differently implicated in those crimes are coexisting together in that community. I think those views from below are actually very helpful. And obviously, the work of philosophy of MacIntyre, I personally find it very, very transformative.
Dr. Haroun Rahimi, thanks for your time and participation in this podcast.
Absolutely. Thanks for having me.
And finally, to our great audience, thanks for listening to this episode. As always, be sure to subscribe and share it with your friends on social media. I'm looking forward to speaking to you and talking to you on the next session.